This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're taking your calls and questions on any legal topic. You call 536-0077. Whether you're dealing with insurance companies that are giving you a runaround about storm damage, maybe you've got questions, it's Ask Us Anything night. Call in about any legal question, medical malpractice, or a pharmacy's giving you the wrong medication. Something new tonight though, not only can you call in your question, you can text your question. You text it to the same number, 256-536-0077. We will pull some out. You can also email us. You can email lawcall@waaytv.com. You can send your email questions any day of the week on any legal topic, and we'll pull some out. We will pull some out for the show tonight. Getting us started tonight, Heath Brooks and Bobby Marsh are here from Timberlake, League and Brooks. Good to have you guys here.
Good to be here. Good to have Bobby here.
Good evening.
Personal injury cases are what you guys do. That's a wide range of things, right?
That's right. Everything from medical malpractice to motor vehicle accidents to pharmaceutical errors. You fall in a store, any of those types of cases we handle.
And we like to start the show off with some video. We pull some video and you make the law call. This is video off of YouTube. So summer travel season approaching, you know, people lose their temper in the heat and people start driving a little bit crazy, road rage on a busy highway. So here we see how quickly things can escalate. Okay, we saw that little bump there, but it's not going to end with that. We've got two drivers. Driver going to come up on them again and watch somebody get out and come back around and punch the driver in the red van. Okay, here we go. Really? Now what you don't see, that you can't see, is the driver of the red van actually had a gun and threatened the guy who punched him with the gun.
Okay.
Okay. Have you ever had a road rage case? Hopefully nothing like this.
We've had road rage cases. We've had road rage cases in situations where, you know, somebody cut somebody off and then that person chased down the person that cut them off and then ran them off the road. And that kind of scenario, when you run somebody off the road because you're mad, it's your fault. You're going to get in trouble for that. Not only is it a civil problem where you may have to pay somebody money or your insurance company may have to pay somebody money, but you may also have to go to jail. So that's one of those things that keep you cool out there. It is hot. There's a bunch of people on the road now. Kids are about to get out of school, but it's never okay. Even if somebody cuts you off, it's never okay to get mad enough to run somebody off the road, to pull a gun on somebody. I mean, people are crazy these days.
Yeah,
they really are.
That one had a gun. It could happen.
Absolutely. And it almost caused a second injury there. He was almost run over after he, ran up to that vehicle.
Yeah,
so.
You back out into traffic again.
But we've had them.
Okay.
We've had them.
So who's at fault then? Okay, so is the person who started it at fault or the person who gets out of their car and comes back around and punches? Who's at fault?
It depends. You got a bunch of different potential problems there. One of the ones is okay, look, if you cut somebody off and then they run you off the road, they're responsible. Just because you cut them off, that doesn't mean you caused a wreck, that doesn't mean you caused an injury. If you hit somebody and then they get mad at you, like what looked out at the video, they get mad at you and walk up to your car and punch you in the face, well, you may be responsible for initially changing lanes and hitting them, but you're not going to be responsible for the fact that they punched you because of it. That's an intentional conduct. That person who hit you, could be charged with assault. And then you pull a gun on somebody, that brings the whole different felony aspect to it. So
they're really just separate situations, separate torts we're talking about.
Yeah, that's right.
Okay. Call in your questions tonight. It's Ask Us Anything night, 256-536-0077. You can also text us tonight. Okay, we got this email question from Tess. Tess had written in, my 14-year-old got his tooth punched out and stitches in his lip. He needs dental work, etc. Other boys' parents want to put it through their insurance. Do I need a lawyer? And how much should be a fair cost? Okay, what can you, if they're offering to take care of it, what do you recommend?
Let's break this down first off. So the first thing you got to take a look at is there going to be insurance involved? So if the child, the 14-year-old, was at school and somebody punched him in the mouth, maybe it was accidental and punched their tooth out, then yes, the parent's homeowner's insurance could be responsible for that situation. So, that would be a claim that would be made against the homeowner's insurance policy of the parents of the fella who did the punching, who maybe accidentally knocked out the tooth. And the question is do you need a lawyer? Well, Bobby, if you get insurance involved, do you need a lawyer?
You don't always need a lawyer. Sometimes you can handle those things on your own. However, insurance companies don't always do what they say they're going to do. And that's why we're here. So if you make the claim with the insurance company and they give you a hard time, or they give you the runaround, they don't want to pay out the claim, you may need a lawyer at that point.
Now, when we're looking at how much the case is worth, that's a whole different ballgame.
Okay.
Because now we're looking at what are the medical bills. How long, is it a permanent issue? How long did you not have your tooth? Did you miss time from school? And if you're 14 years old, one of the things that you have to do is you can't just accept an amount from the insurance company. You actually have to have a judge approve your settlement. So that's a pro-AMI hearing. The fancy legal term is a pro-AMI hearing, where we got to go to court and make sure that that's a fair settlement. So there's more to it there than just what's my case worth. There's a lot of factors that go into that.
We've got callers waiting. We've got Sharon on the line with a question from Huntsville. Hi, Sharon. Thanks for calling. What's your question tonight?
So we brought our vehicle in, a company vehicle, for repairs months ago, and have not been able to contact the mechanic who was doing the repairs. And it's like I said, months and months, and we don't know what recourse we have at this point. Is this a Grand Theft Auto situation? What do we do to get the vehicle back?
Was this in Madison County?
Yeah.
Okay. So here's the deal. When you have entered into a contract with somebody, that's what you do. When you take your car in, you enter into a contract with them, and then you say, okay, in exchange for me giving you money, you're going to repair my car. And you expect that to be done in a reasonable manner. We call that a workmanlike manner. So when you bring your car into a repair shop and they just don't call you, don't contact you, don't get back with you, then what do? Well, the first thing you can do is you can go down there and you can get your car back. If it's not running, then you can get a wrecker and you can have the car removed and bring it back to your place of residence. If it's no longer there, if the car is gone, then you may have an action for the value of the car against the repair shop. And so what you would do is you would go to the small claims court or the district court in Madison County, is the 8th floor of the courthouse, and you would file a claim against the mechanic who was supposed to be repairing your car but did not. And that's kind of how you may have it. That's your next form of recourse, is potentially getting going to small claims court. Very difficult though if you're going to go and confront somebody like that. Be careful about that.
Okay. We got a text in. This is from Phil. Phil in Madison County says, do courts truly recognize online wills? Okay, I'm guessing he's talking about wills that you do yourself. You type it up and sign it. Can you do your own will?
You can do your own will in the state of Alabama, but you have to have 2 uninterested witnesses sign it. And when I say uninterested, meaning they don't take anything from the will. Now, is it advisable to do your own will? One of the things about a will is that the last thing you want is you don't want your family to have to be worrying about how your property, your house, your cars, all of those things are going to be distributed when you ultimately pass away. And it's always advisable to talk to a lawyer about your will. That's particularly true if you have children, if you have real estate or property. But if it is an online will, and it has been notarized with 2 independent witnesses, then the courts could recognize it, as a valid will.
We've got Tammy on the line with a question from Moulton. Hi, Tammy. Thanks for calling. What's your question tonight?
Yes, I was calling about an estate, a probate estate. Recently, I had went to go to court over a truck that I would not turn over because my dad had gave it to me, but I didn't have it in writing, but I had witnesses. And so therefore, when I didn't turn it over to my brother, he was made representative. So when I didn't turn the truck over, then we specifically had to go to court over just the vehicle. Mm-hmm. So I wouldn't turn the truck over, so they took it upon themselves. The judge did. The judge came out here with a tow truck and retrieved my daddy's motorcycle, my daddy's lawnmower trailer, and my daddy's truck. Therefore, I was making payments on the motorcycle, which was fine if they wanted to get it, but the main thing was the truck had been given to me. But my question is is it right for an attorney and for a judge to come out and retrieve property, a probate judge?
Let me ask you, did it sound like this is the final decision, or this is just gathering all the things?
This was just the estate. We still haven't came up for the estate yet.
Okay.
That was supposed to have been just for the truck, for the vehicle.
I gotcha. Okay.
What do you think?
So here's the deal. Whenever you're dealing, and we were just talking about this, whenever you're dealing with what happens to your property after you pass away, it is essential for it to be in writing. The having a witness that your daddy told you could have the truck. Well, that could help in some certain very rare circumstances, but probably not in this one because it's not in writing. And if your daddy didn't have a will, then all of his property is going to pass by what's called intestate, fancy legal term again, intestate succession. And that type of passage of property is determined by the state of Alabama for folks who do not have wills. And that property is going to pass evenly to the heirs at law. So in other words, if it's you and your brother and you are the only two heirs, then your daddy's property is going to be split evenly. And if your brother is the personal representative of the estate, then he's going to get to drive the train on how that property is distributed. In other words, he may sell your dad's truck, he may sell your dad's motorcycle, get fair market value for those two pieces of property, and then split the proceeds. He would be required to do that under the law, or at least be fair in the manner in which he is distributing the asset to the heirs. He actually has a fiduciary responsibility to you to make sure it is fair in the distribution. But in terms of they call that specific bequests. Specific bequests of property that are not in writing will rarely be upheld by a court in this scenario.
Especially when it's against what is in writing.
That's right, yeah.
They're telling us take a break. We're going to take a break. We've got more texts coming in. We got callers waiting. Stay on the line. It's Ask Us Anything night, and we'll be right back.
You're watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi, and hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. I'm Sharon Doviet. Tonight it's Ask Us Anything night, so call in, or you can also text in now. You can also email in. You call in 256-536-0077. We've got with us Heath Brooks and Bobby Marsh, both from Timberlake League and Brooks. And we've got folks texting in tonight. Okay, we've got a question about storm damage. If a neighbor's tree falls on your property, who is responsible for getting that cleaned up? Boy, we had that happen all over the Tennessee Valley this past couple of weeks.
Lots of trees.
What do we do with this if it's a neighbor's tree?
So if it's your neighbor's tree, ultimately it could be on your neighbor because again, it's from their property, it fell on yours. So I would have a conversation with your neighbor about getting that removed. Now, if it's your tree and it falls in someone else's house, that may be your responsibility because ultimately you're responsible for the trees that are on your property. Now, this is a question I've had before. Someone called and they asked, hey, I think my neighbor's tree is about to fall on my property. What can I do about that? And the important answer to that is, unless it's crossed your property line, there's not much you can do. So if you think you're about to have a tree fall on your property, I would recommend talking to your neighbor and saying, hey, I think we need to do something about this tree before it creates a property damage issue.
And I'll add just a little bit to that. That's exactly right. You know, one of the things that we look at in the law is, if it is my tree, is it a healthy tree? And if the tree's healthy and it falls on my neighbor's property, I'm not responsible. But if my neighbor's tree is healthy and it falls on my property, my neighbor's not responsible. It really turns on whether the tree is diseased or dead. And I had this issue happen. I had a neighbor's dead tree. I tried to help him clean it up, and it ultimately fell on my roof, and his insurance company was responsible. Yeah.
We're seeing a lot of insurance things happening after the tornado.
Tell you what.
We've got Greg on the line with a question from Collinsville. Hi, Greg. Thanks for calling. What's your question tonight?
Yes. My name is Greg Greathouse. I've been having this insurance that I had for 13 years. Since my mom had passed, I've been paying on it for 13 years. What can I do about it? It keeps going up and up and up.
What's the insurance on?
Yeah.
Life insurance, or it's a house insurance? What is it?
Life insurance.
And the rate keeps going up.
Well,
Yes,
well, I mean, is it your insurance? Is it your life insurance policy on your life?
Yes,
Okay. So it's common, if you have term life insurance, is what that is called. If you have term life insurance, then generally that'll be a set rate for the term of the insurance that you'll have to pay every year until that term ends. So if it's 20 years from the time you're 35, at 55 your term ends, and then you can have a higher rate being charged. If it's not a term insurance policy, if it's a whole life insurance policy or something different, then the insurance company may be able to increase your rate every year based upon your age, your medical conditions, those sorts of things. What you need to do is you need to actually get your policy of insurance from the life insurance company. Take a look at what you got. Take a look at when the insurance company has the right to raise your rates. And if they're raising your rates and that's not something that's in the policy, well, then you may have a claim against them. You may have to tell the insurance company, hey, look, you've been charging me too much. But if they are doing what they should do under the policy, then you'll have a decision of whether you want to cancel the policy and move on to something different or continue to pay the higher rates.
We've got Joe on the line with a question from Falkville. Hi, Joe. Thanks for calling. What's your question tonight?
Hey, how y'all doing?
Hey, we're doing good.
Joe.
How are you? What's your question, Joe?
All right. I just kind of wanted to know, and just something I've been kind of thinking about. My company's closing, and they got bought out by a big corporation,
Okay.
and they're totally closing down and consolidating, and what our managers are telling us is we're all offered jobs in Muscle Shoals and stuff like that. But my thing is like a lot of us can't make that drive to Muscle Shoals, and we're not going to. And they put a warning notice in. I don't know if y'all know what that is, but it's a notice, and it came up on the news that they were closing down and the layoffs were going to start August 15th. They told us there wasn't be nothing done until next March. And I kind of wondered, what are we going to do? Me and my wife both work there. Like, if they come and just shut the doors one day, is there anything we can do as employees?
Well, you obviously you don't have any power to keep the company going when they close down. You may be able to file for an unemployment claim with the state of Alabama, and I know that process can be arduous, long. It can take a lot of time to go through that process, but you can potentially, if you're laid off from your job, file for unemployment. But just taking off my lawyer hat for a minute, it seems like this company may not be a stable work environment, so it may be time for you to start looking for another pasture.
Okay, we got man wrote in. This is from Brian. Brian texted us. Thank you very much for your text. Man with no liability insurance on an electric scooter hit my wife's car, rear passenger door, as she was turning right. My insurance said they can only go after the other party if they have liability insurance. Can I sue for the full cost of the repair or only just my deductible?
What do you think, Bobby?
Well, you could always go after the full cost of repair. However, my first recommendation would be if you have underinsured, uninsured motorist coverage, to try making a claim through your own insurance. In that situation, it would work just like any other insurance claim, except you're actually using your own coverage. And this way you're out of, just in case the man on the scooter didn't have any assets or things for you to go after, which, as in our experience, can be rather difficult to go after someone's assets if they have any in the first place. So my recommendation would be go after your own uninsured, underinsured motorist coverage.
Yeah, that's always a good idea. I mean, if you have the ability to go after your uninsured motorist coverage, then it may be a situation where, depending upon the cost of the damage. I mean, if we're talking about $500, then you may be able to file a claim against the fellow that was on the scooter, go to a small claims court in the county in which it occurred, and plead your case to a judge and get your money. Sometimes it's like putting good money after bad, though. If you pay $340 to go file a lawsuit, you end up getting a $500 verdict from it. Now you have, to go collect that $500 to somebody who's on a scooter who didn't have insurance to begin with. So you could be $840 out at the end of the day. Sometimes I don't know what the cost of the repairs of your car, but if it's significant enough, then it should be something that you should talk to your own uninsured motorist carrier about. If you just really have an axe to grind, you can take it to the small claims court, the district court, or the county in which it occurred.
Let's see if we can squeeze in John from Collinsville. Hi, John. Thanks for calling. What's your question tonight?
Yes, ma'am. I have a question about, I have a neighbor that has a handyman that cuts their grass. They don't live in the house often. They live out of town. And the day that he cut the grass, some debris went and bust out both of my double windows. I reached out to talk to him, and he called her the day, and she said that she don't think it happened since it was that far away, which it was. Then he came back the next day and said that she said for him to fix it, and she'll pay him. But now I reached out again. I can't get in touch with her or him.
Yeah.
So I'm trying to figure out what should I do.
Well, they're mowing in close proximity to a house.
Yep.
If you throw debris into somebody else's house when you're mowing in close proximity to a house, we've actually had this type of case. They could be responsible. They could have a homeowner's insurance policy you may be able to file against. Again, you may be able to file a complaint in the district court or in a small claims court. Have a conversation and say, look, you shouldn't have been mowing close to my house. These are my damages. Go ahead and get a estimate for the damages to repair your window. I mean, if you got to replace windows, that can be expensive.
Yeah, it can.
I mean, that can be expensive. So go ahead and get that estimate repair so that you know, and then present it to them and say, hey, look, this is what this caused, and y'all were mowing without a guard or too close to our house.
They're telling us to take a break. We'll be right back. Answering more of your questions. It's Ask Us Anything night. Stay with us. If you didn't get your questions answered tonight, here's how to get in touch with Heath Brooks and Bobby Marsh with Timberlake League and Brooks in Huntsville, 256-536-0770 or 800-804-2502. They are personal injury attorneys, so that's everything from nursing home negligence to car accidents. Also check out law-injury.com, and if you like them on Facebook, you can learn more about the law that way.
And Sharon does everything family law. That's anything from divorces to child custody, child support. She can be reached at 256-539-7337 or www.sharonfamilylaw.com.
Okay, somebody says food poisoning in a restaurant. Who do you sue?
The restaurant.
Sue the restaurant.
Yeah, sometimes it's the producer, sometimes it's the manufacturer of the actual product, hamburger meat, but most of the time it's the restaurant.
Folks who served it.
Thanks for all your calls, your questions, and your texts tonight. We'll do
Have
that
a great
again next
night.
week. Thanks.